Start. Having said this, it needs to be emphasized that the existence of jurisdiction and the nature of its exercise have distinct connotations in constitutional law. Stop. The Armed Forces Tribunal is constituted by legislation which provides for a specialized and efficacious administration of justice in matters falling within its jurisdiction under the provisions of the Act. Stop. This is coupled with the need to maintain discipline in the armed forces. Stop. The Armed Forces Tribunal is a court of first instance and ordinarily, matters which fall within the purview of its jurisdiction have to proceed for adjudication before the tribunal and tribunal alone. Stop. Against the decision of the tribunal alone, there is a statutory remedy of an appeal which is provided under section 30 and 31 to the Supreme Court. Stop. Since a statutory remedy of an appeal is provided, the principles which we are well established for the exercise of the jurisdiction under Article 2 to 6, would warrant that the High Court should be circumspect and careful while determining as to whether any case for the exercise of jurisdiction under Article 2 to 6 of the Constitution is made out. Stop. The jurisdiction under Article 2 to 6 has not been abrogated, as it could not have been, being a basic and essential feature of the Constitution. Stop. The apex court in Union of India versus Major General within bracket Supra has held as under. Stop. The aforesaid decisions rendered by this court can be summarized as follows. Stop. The power of judicial review vested in the High Court under Article 2 to 6 is one of the basic essential features of the Constitution, and any legislation including the Armed Forces Tribunal Act, 2007 cannot override or curtail jurisdiction of the High Court under Article 2 to 6 of the Constitution of India. Stop. The jurisdiction of the High Court under Article 2 to 6 and this court under Article 32, though cannot be circumscribed by the provisions of any enactment, they will certainly have due regard to the legislative intent evidenced by the provisions of the acts and would exercise their jurisdiction consistent with the provisions of the act. Stop. When a statutory forum is created by law for redressal of grievances, a writ petition should not be entertained ignoring the statutory dispensation. Stop. The High Court will not entertain a petition under Article 2 to 6 of the Constitution, if an effective alternative remedy is available to the aggrieved person or the statute, under which the action complained of has been taken itself, contains a mechanism for redressal of grievance. Stop. The apex court in Union of India versus Major General within bracket Supra has highlighted the anomalous situation that will be created in case the statutory alternative remedy is permitted to be bypassed. Stop. In this reference, attention is drawn to paragraphs 43 and 44 of Union of India versus Major General within bracket Supra Stop. Section 30 provides for an appeal to this court subject to have granted under Section 31 of the Act stopped by Clause 2nd of Article 136 of the Constitution of India, the appellate jurisdiction of this court under Article 136 has been excluded in relation to any judgment, determination, sentence or order passed or made by any court or tribunal constituted by or under any law relating to the armed forces. Stop.